David Lange is an icon in the area of intellectual property law in the academy and especially with respect to copyright law. I am personally thrilled to be able to have him here for this program today. Probably in my part of the talk, I'll tell you a little bit about how this program came to be. But for now, what I'd like to do is just introduce Professor Lange. Professor Lange is the Melvin G. Shim Professor of Law at Duke University School of Law. He's been a member of the faculty since 1971. Prior to that, he had an active career as an entertainment lawyer working in radio, television, motion picture production. He was a practicing attorney. He's acted as counsel in a number of venues. As a scholar, I have actually had the pleasure of reading a fair bit of David's many law review articles. And those of you who are in my survey class know that we use the case book that Professor Lange is the lead author. His scholarship is eloquent, as is he, well-crafted, thoughtful, and provocative. In the book that he co-authored with Jeff Powell, his colleague, also his colleague at Duke who teaches constitutional law, No Law, Intellectual Property Law, in the Image of an Absolute First Amendment, one of the reviewers of this book on the dust cover said that this book will be destined to be one of the most important works on intellectual property this century. I completely concur with that. And therefore, it is my great honor and my great pleasure to introduce to you Professor David Lange, who will share with you the first part of this program, which will focus on the theory of absolutism that he and Professor Powell develops in the book, as well as a countervailing theory by Justice Holmes. After that, I will talk about how we can extrapolate the theories that he's talking about and put them in the context of Jewish law, which I believe is fair to say is a connection that perhaps the co-authors of No Law did not expect when they were writing this. So it's my great pleasure to present Professor David Lange.
Well, many thanks to Bobby. Have I put this?
Oh.
Okay, I'm not sure that it's actually working. Okay, all right. And everybody can hear me in the back, no problem. All right, good. I'll speak up. I actually went to acting school at one point and learned how. So mic or no mic, I'll try to make myself heard. I'm very grateful to Bobby and to you for allowing me to join you in this celebration today. I do think of it as a celebration. I know that more is at stake than just a conversation about the book that Jeff and I wrote, or in some ways the even more important review of that book that Bobby wrote, which he'll talk to you about momentarily. Momentarily, when I use it, is an elastic term. In this particular case, it means in about 15 minutes or so. And I think that will keep us on time. Is that fine? I brought this with me intending, actually I timed it out and I meant to read it, but because, as Bobby knows, my plane was late, I think I'll just put this to one side and talk to you about things that I already know and much of which I would have read to you, or at least would have presented to you from this paper. I'm grateful, as I say. I won't take too much of your time. I do want to talk about the book and the ideas that we present in the book. Some of you, how many of you are intellectual property lawyers or intellectual property lawyers manqué? I want to say, by way of disarming your objections, that I do not for a moment think that I know more about copyright than you do. On the other hand, I think I probably know as much about copyright as you do. So I take it that when we discuss the ideas that Jeff and I have presented in our book, we will be dealing with each other inter pares. I think we will come, I expect, at the subject from a somewhat different perspective, and we may end up having to agree to disagree. But nevertheless, I look forward to the conversation that I expect we will have. And I know there are a number of students here in Bobby's class. Am I right? Have you gravitated toward the back? Is that what's happened? That happens at Duke, too. I don't know quite why, though I have my suspicion. Toward the end of any talk, particularly if the talk is not particularly lively, the back row's empty and it's just closer to the entrance and the exits if you're sitting toward the back. So I'll understand if you fade away as time passes. Here's how this project began. Not the project quite that Jeff and I wrote about. I'll get to that in just a moment. But the project that Jeff and I wrote about as seen by Bobby began, I think, in some ways, what would it have been, Bobby, maybe 10 years ago or so, when she was at Duke and gave a talk. And I said in the course of a conversation, not entirely unseriously, that it seemed to me that there was something about copyright that was somehow Jewish. And I said, knowing Bobby, I can say this to you, but being a Gentile myself, I have to be careful about how I say it in a more general sense or against a more general audience, because people may misunderstand me. I don't mean that it's bad, as the Nazis used the idea of Jewish science to mean something bad. The truth is, I just thought that there seemed to me to be something about copyright that was, well, somehow faintly touched with Jewishness. Now, I think I had two things in mind, frankly. One was that I was then a member, I think I was then a member of the Board of Trustees of the Copyright Society. And it's true that the Copyright Society is almost overwhelmingly Jewish in its membership. So there was some sense, I think, in which I thought that might have flavored my sense of it. Also, Mel Nimmer, who was a great friend and I think a great copyright lawyer, I think the greatest copyright scholar ever, was Jewish, and his son David, who now manages his casebook, is devoutly Jewish, more so I think than Mel was. And so there was that. But the thing that I think really prompted me to make this remark to Bobby was something about the degree to which copyright is about the word. And when you think about the word, as you do in copyright, about expression, it just somehow seemed to me redolent of what I think of as the Old Testament. And what I believe, though you'll correct me, is the Talmud. Am I correct about that? Or the Torah, or whatever. I leave it to Bobby. I'm out of my depth here, and I will leave it to Bobby to respond. But that wasn't at all what Jeff and I had in mind when we wrote. We were serious about an idea that had been on my mind for some time. I practiced law beginning in 1964. Some of you will remember that it was 1964 when New York Times versus Sullivan was decided. This was the great case involving the New York Times in which Martin Luther King had been accused of, and his followers had been accused of a libel in connection with a newspaper advertisement that they had published in Alabama. Now, the contents of the advertisement were, I think, substantially true. What the advertisement said was that civil rights marchers had been mistreated and abused by particularly the citizens of Birmingham, I believe it was, but it may have been Montgomery. But they were sued because there were some things about that advertisement that were wrong, and those things made the publication, the advertisement at that time, libelous under not just the state law of Alabama, but under the state law of almost any state you could name. There was no privilege in that moment when the ad was first published in the early 1960s that would, as today would be the case, that would have protected Martin Luther King and his followers. And so the case made its way through the Alabama courts against a judgment in the lower court awarding very substantial damages. Damages enough against the principal defendants as they were nominally to be seen, namely Martin Luther King and his followers. But the real target of the judgment was a judgment against the New York Times. And the thought clearly was that if you could make the New York Times pay enough, then you would probably shut down some of the carpetbagging that the people of Alabama and elsewhere, and not just in the South, but particularly at that time in the South, saw as rampant. The Supreme Court took the case. I'm assuming that many of you, I look around and suspect that many of you are my age, but many of you may not know this case intimately. The Supreme Court took the case and said, when a public official is the subject of a libel action, or as the court later said, when a public figure is the subject of a libel action, and the libel is published without any reckless disregard for the truth or any knowing falsehood, then in those circumstances, there can be no recovery. There can be no recovery of nominal damages, no recovery of absolute damages, none of the things that were at that time, or prior to the Supreme Court's decision in 1964, none of the things that would have been a problem for the New York Times. Now, I represented at that time, my firm and I with my firm, because I was very young, represented the Chicago Sun-Times and the Chicago Daily News and many other clients who were across the country involved in newspaper and magazine and television and media publications, including some clients who were individuals of note, such as, for example, the late Mike Royko. And we followed this litigation very closely. It was important to us to keep up with it. Indeed, what we did was try to stay ahead of it, and generally speaking, I think we did stay ahead of it. But I realized as the years passed that my own sense of the First Amendment, which was growing by leaps and bounds, was diverging somewhat from the partners with whom I was engaged in this practice. They understood that the First Amendment was in some sense a qualified proposition, that it had to be balanced against other interests that might from time to time contend with the First Amendment for primacy of place. But as, again, some of you at least will remember, sitting on the court at that time were two justices who believed otherwise. One, the more famous of the two in this context, was Justice Hugo Black. Justice Hugo Black was an interesting character in many, many respects, but among them was his belief, and it was a belief. I think it needs to be understood as a belief system in his person, a belief that the First Amendment was absolute. As he said, no law means no law, and no ifs, ands, buts, or whereases. It's just the proposition as it appears in the First Amendment, which in relevant part says, Congress shall make no law abridging freedom of speech or of the press. And for whatever reason, I think I know the reason, I think it was because I grew up in the McCarthy era and had thought at the time that the First Amendment was being repeatedly violated by Congress in its House Un-American Activities Committee and its prosecutions and pursuits of people for the things they thought and said. But for whatever reason it may really have been, I actually came to think that Justice Black was right. And that was in the period from roughly 1964 through 1971, which was when the New York Times privilege reached its zenith. After 1971, it began to recede somewhat, and after 1971, really after 1973, it began to retreat into something more moderate, even than it had been in its heyday. And meanwhile, of course, Justice Black had retired in 1971, died a month after his retirement in the fall of '71, and so no one was at that point proposing that the First Amendment was an absolute in the way that they had done. Now, something interesting, though, had happened meanwhile. In 1970, Melville Nimmer, the great copyright scholar, was asked to deliver the Brace Memorial Lecture to the Copyright Society, an honor roughly equivalent to an Academy Award by copyright people. And he gave the lecture in New York at Columbia, where it's usually given. And he asked a question that he thought was a fair question, and one that I think was a fair question too. Does copyright violate the First Amendment, he asked. And in 3 paragraphs, he responded to his question, a rhetorical question, but he responded in what I think to be the most persuasive language that anyone has actually ever offered. In fact, in the book that Jeff and I wrote, we really deliberately take these 3 paragraphs as if they were our own. We identify them, of course, but we set them forth because I don't think anyone could argue more effectively than Mel Nimmer did. Let me read you just that much of what appeared in this essay that first began as a speech to the Copyright Society and then was reprinted in a somewhat revised and somewhat larger version in the UCLA Law Review later in 1970. This is what Mel wrote. The First Amendment tells us that Congress shall make no law abridging the freedom of speech or of the press. Does not the Copyright Act fly directly in the face of that command? Is it not precisely a law made by Congress which abridges the freedom of speech and of the press, in that it punishes expressions by speech and press when such expressions consist of the unauthorized use of material protected by copyright? The language of the First Amendment does not limit its protection to speech which is original with the speaker, but rather states that Congress shall make no law abridging freedom of speech. And Mr. Justice Black has said that this reference to no law means no law, without any ifs or buts or whereases. Now it might be contended, Mel went on to write, it might be contended that copyright laws fall within a built-in exception to First Amendment protection, not by the words of the First Amendment, but by reason of another passage of the Constitution, namely the Copyright Clause, expressly authorizing Congress to grant to authors the exclusive right to their writings. But if the constitutional grants of power to the Congress were not subject to the limitations imposed by the Bill of Rights, then such limitations would have no meaning at all to a government whose only powers are derived from just such grants. Yet, if the Copyright Clause does not render the First Amendment inoperative, why does not the contrary conclusion follow? Doesn't the First Amendment obliterate the Copyright Clause and any laws passed thereto, pursuant thereto? This returns us to Mr. Justice Black's absolutist approach. It cannot be denied that the copyright laws do in some degree abridge freedom of speech, and if the First Amendment were literally construed, copyright would be unconstitutional. Now, in that particular passage, those 3 paragraphs, which I have ever so slightly edited and rearranged, but not, I assure you, in any way that does justice to the text. If the First Amendment were an absolute, Mel Nimmer says, and I think says in those 3 paragraphs very persuasively, there really would have to be a conflict between the First Amendment and copyright. But in truth, Mel was not really making this argument. What he was doing in this passage was acting as a kind of devil's advocate, and then in what followed in his essay were a series of responses to the questions that he had put and this early elaboration on the subject. What he said, I'm now greatly foreshortening what he said, were these things. He said, in truth, we don't think that the First Amendment is an absolute. We don't take it the way Justice Black took it. Instead, he said, and this was typical of the time, the tests have somewhat changed in the years since, Mel said, what we actually do is we engage in what was then called definitional balancing, so that we posit on the one side interests that are advanced by allowing the First Amendment to be somewhat set aside. And on the other side, we allow the First Amendment to have sway in cases in which it really is more important than whatever it is that's being advanced by setting it aside. That's the essence of balancing. It's an approach to the First Amendment that Mel did not invent. It was, in fact, not invented in the true sense by anyone, but it was suggested by the jurisprudence of Justice Oliver Wendell Holmes, who believed that the approach to the Constitution that we ought to follow was a balancing approach. Some of it, I think, undoubtedly has to be balanced. The Fourth Amendment cannot reasonably be read as not imagining a balance. Some of it, I put it to you, however, is not clearly the subject of any balance at all. So that what Holmes brought to the task was the sensibility and the judgment of a common lawyer, which was in fact what he was. He had served on the bench in Massachusetts, in the Supreme Judicial Court of Massachusetts. Before coming to the Supreme Court, he was not a young man. He served during the Civil War. His sensibilities were really not necessarily in keeping with the First Amendment, which I want to remind you, those of you who know, and tell you, those of you who haven't yet had reason to find out, was not construed, the First Amendment, until after 1918. No Supreme Court case had ever seriously considered the meaning of the First Amendment until 1919 in a series of cases following up on World War I, when dissident speech was the subject of efforts to prosecute the speakers. I think that that Holmes got it wrong. I think that the long wait between 1791, which was when the First Amendment was proposed and ratified, and 1919 allowed us to go through a period in which we've never really taken the First Amendment as seriously as we should. Now, I'm not an originalist. I don't think you go back to the Constitution and try to imagine exactly what it was that the framers thought or had in mind and then apply their thinking, their reasoning, their aims in order to judge what the language should be. That may or may not be an approach favored by, for example, Justice Scalia, but it's not the approach that I actually favor. But I do think that you begin with the text. And the text in this case, I put it to you, is really quite clear. It says Congress shall make no law abridging freedom of speech or of the press. And there isn't any question, and even Mel Nimmer himself wouldn't have disputed this, there is no question that copyright abridges freedom of expression. It simply does. That's a very considerable part of what it is meant to do. And it is meant to do it because abridging freedom of expression is thought to advance expression. Justice O'Connor said in the Nations case, the magazine case involving Gerald Ford's memoirs in 1984, I think it was, or maybe 86. I'm sorry not to remember. I've got it here, but I don't want to waste time looking it up. Although if I keep digressing, I just do as well to do that. In that case, Justice O'Connor said the framers really thought that copyright would be the engine that would drive freedom of expression. Well, let me set that silly thought to one side. The framers had no notion of that kind. That's just bogus. It's the kind of Supreme Court history that you really need to learn to eschew, avoid, and set aside. There is no argument worthy of the name suggesting that the framers thought that the copyright had any relationship to the First Amendment at all. Not positive, not negative, not at all. The Copyright Clause was introduced without debate in the summer of 1787, 4 years before the Bill of Rights was introduced. The Bill of Rights had not yet really been considered in any serious way. It almost didn't pass when the Bill of Rights finally passed and the First Amendment was finally ratified. And by the way, it was not the First Amendment when it was first proposed, though it became one eventually. The framers had no particular thought of a relationship between them at all. No one seriously can make that argument. And the fact that her name is Justice O'Connor doesn't mean that she can either. That's just bogus. So Jeff and I decided that we would write a book that we would call No Law, which we subtitled Intellectual Property in the Image of an Absolute First Amendment. And in this book we suggest that if you really do consider the history of the First Amendment, and you consider the meaning of the First Amendment as you can infer it from the text, and if you take into account the First Amendment as it was understood by the framers, not in a close-grained originalist sense, but as evidenced by the things they did and did not do, and the things they did and did not say, then it's perfectly plausible to imagine that the better reading, not the only reading, but the better reading of the First Amendment is that it really is an absolute. Now, the question then is, what does happen to copyright? Mel suggests, I think far too broadly, that copyright is then simply unconstitutional, but I think not. I think that copyright can survive in a very considerable part, but here's what must change. First of all, exclusivity of the kind that copyright allows clearly cannot survive an absolute First Amendment. You cannot have an absolute First Amendment and sustain the idea that the rights of the copyright proprietor allow that person to prevent others from appropriating the speech, the expression, not just the ideas, but the expression as well, for whatever purpose they may wish. That can't survive in the teeth of an absolute First Amendment. But on the other hand, you can certainly provide that in cases in which the speech is appropriated, the copyrighted speech is appropriated for the sake of additional money-making ventures, then just as we do with infringement theory, money, net revenues generated by those appropriations may sensibly be shared and may be required by Congress to be shared with the copyright proprietor. There's nothing wrong with that. It doesn't violate an absolute First Amendment. What is more, there are many kinds of ancillary interests that are not affected by an absolute First Amendment. Item, Bobby's own particular scholarship, which deals at length and brilliantly with the idea of moral rights, is to a considerable extent unaffected by an absolute First Amendment. You can't, of course, prevent someone from appropriating speech and abridging it or truncating it or distorting it. That's the essence of what appropriation allows. But there's nothing wrong with requiring that people be acknowledged as authors. There's nothing at all wrong with that kind of requirement. It isn't very well recognized now, but Congress could do more than it's now done. And what is more, it is possible to set aside things like fiduciary obligations so that if you're a writer and you share work with a writing group or with your agent, or you send it to a prospective publisher, that doesn't necessarily mean that you lose your control over that work. Nor would it mean that someone like Emily Dickinson, who wrote hundreds and hundreds of poems, not wanting them to be published, would lose her right to control the publication. There's nothing that allows an invasion of privacy from within the perspective of an absolute First Amendment. These are the principal things that you would pay attention to if you had an absolute First Amendment. Much of copyright would survive, but I will admit that much would not. And I will say, in response to the questions that I think you will ask, I will say why it is that I think that doesn't matter much, why the changes would not decimate the idea of creativity or expressivity. It would simply require us to think about those things in a different way. Bobby, I'll defer now to you. Okay.
Technology.
Did you knock out a...
I think I did, but I think I'm good.
Okay, if it doesn't work, I can give you mine.
Okay, thank you. Well, thank you very much, David, and I look forward to continuing this discussion. So David asked how many of you are intellectual property attorneys. I'm going to start my comments by asking how many of you are here for the CLE component because of the Jewish content of this CLE component. Okay, all right, good. Well, this is actually a little challenging because we have a very mixed audience, and some of what I'm going to be talking about will require discussing some things that for some of you are just second nature and you know very well, and for others, this may be the first time that you hear some of these concepts. But I want to start by sort of giving a little more content to the history of this particular program. What David said is very true about the conversation we had 10 years ago. But much more recently, last year, Duke was very kind enough to ask me to come. Duke was doing, the law school was doing a celebration of the book that Jeff Powell and David wrote, and they asked me to come do the keynote. And unfortunately, I couldn't that time, and I felt really badly, and I said to David, I will do a book review, how about that? And he said that would be great. So I got my copy of No Law with no preconceived notion of what I would write about. I promise that. To the extent I had any preconceived notions, I thought maybe I'd write about moral rights because I was in the midst of thinking very actively about moral rights at that time. And lo and behold, I started reading and reading and reading, and it is an engaging, wonderful book, and I do recommend it for those of you who really want to think more carefully about First Amendment and copyright and the intersection of that. But as I really almost was finished with the book, that light bulb goes off, that eureka moment, and that we IP people like to talk about. And I realized that what David and Jeff were talking about when they present their absolutist view as filtered by Justice Black was something that was very familiar to me and that I've been thinking about for a very, very long time. And what they were decrying, namely the Holmesian view, the balancing view, was something even more familiar to me because it was a way of looking at Jewish law that, for me, is very second nature, given that it is kind of how I've always thought about Jewish law. And the light bulb went off, and I thought, that's the angle that I'm going to talk about in this book review. So I called David, and I said, I think I found my angle. It's not what you're going to think. But he and Jeff Powell both were amazingly gracious about letting me explore their theory of law in a completely different context. So one's theory of law clearly matters. The approach to what one takes to how the law should be crafted influences not just how the law should govern, but how any one particular law should be applied in any given situation. So theories of law are very, very, very critical. And that's true in the sense of First Amendment and copyright, and it's also true with respect to Jewish law. In the author's view, David and Jeff's view, an approach that calls for balancing the First Amendment's language against individuals or societies' modern day sensibilities has cost us greatly in terms of copyright law and the intersection with copyright law. Jewish law, Judaism, is a religion of law. Okay, for those of you who are not familiar with Jewish law, Judaism has laws about everything, even the order in which you put your shoes on in the morning. It is a legal system that really engrafts every dimension of human behavior. But there are different theories of law within Judaism. And some of what I'm going to talk about and extrapolate from the No Law Project is going to illustrate that. As David mentioned, according to Justice Black's theory, courts are given the power to interpret, to explain, to expound upon the Constitution and their laws, but not to alter, amend, or remake them. And that's a significant distinction. And overall, Justice Black had an insistence on the primacy of the constitutional text as it stemmed from his concerns about the function of the Constitution and the role of the judiciary in applying the Constitution. The authors of No Law propose that the First Amendment must be uncoupled from this early 20th century understanding that really we need to navigate and apply First Amendment in the context not just of what the amendment is saying, but also in the context of modern day sensibilities and modern day balancing. So with that in mind, I want to start by telling you a little bit about Jewish law so you can begin to see the parallels. Jewish law starts with the written Torah. This, by the way, is the 5 books of Moses. Throughout much of Jewish history, a large number of Jews believed that the written Torah essentially was communicated directly from God to Moses, a sort of literal transmission type of communication, and that the words that exist in the 5 books of Moses were God's words, or as my colleague Steve Resnikoff has written, at least the words that God wants us to have. Now, Judaism, having said that, is not a fundamentalist religion. It is not a religion at any level, under any theory of law, that says the words of the text in the 5 books of Moses mean only one thing. That's not the way Jewish law works. All right, why not? Because in addition to providing Moses with the written law, God also provided Moses with the oral law, or the oral Torah. What is that, and how does that apply to Judaism? All right, and it's important to understand this, to understand the parallels between the absolutist version of First Amendment law that David is talking about and what I call the Orthodox approach to Jewish law. And after we talk about that, then we'll talk about the Holmesian balancing approach and how that has a parallel to the historical movement in Judaism, which is basically become ensconced in the conservative movement. Okay, so back to the oral law. The oral law, the commands that God gave to Moses, was intended to provide a kind of guidebook or instruction manual. Okay, if you read the 5 books of Moses and you read the language of it, you might see that there are some contradictions. There are places it's hard to understand. And the function of the oral law essentially was to supplement the text of the written Torah, to provide clarification in some instances, or even in certain instances to alert the reader to when the text has to be understood in a deeper meaning than what's on the surface of the text. So one example that I think many people here might be familiar with is the language in Exodus of eye for an eye. And most people assume that that means that if you knock someone else's eyes out, the Bible allows you to, if someone knocks your eyes out, the Bible allows you to do the same. Okay? That's not at all how Jewish law interprets the eye for an eye. Okay? From the beginning of the tradition, that's been understood to require monetary compensation. Okay? It is never about exacting physical punishment just because you have been physically punished. How do we know that? It's not in the text of the written Torah, it's in the text of the oral Torah. That's how we know that. So then the question becomes, how has the oral Torah been transmitted? Okay. The oral Torah, by tradition, was transmitted from generation to generation, beginning with Moses, and then going down to those who received what is called Mosaic ordination. And through that process of oral transmission, the oral Torah began to be transmitted. But as history would have it, there came a time, and this was in the early, around 200 Common Era, where there was a really strong feeling that the oral Torah, which was intended to be the guidebook to the written Torah, had to be written down. There were persecutions going on. There was a lot of dynamics going on which would make the oral law lost. And so around the year 200 of the Common Era, a document called the Mishnah was redacted. What the Mishnah does, very simply, is provide a series of legal conclusions. It's terse. It's not written in flowery language, and basically you can reverse engineer the rulings to get a more deeper understanding. After the time of the Mishnah, that's around 200 Common Era, there were continuing debates within the Jewish academies as to what the Mishnah means, and still what the text of the written Torah means. And this continued till about the year 500 of the Common Era, at which point the Babylonian Talmud, which is the central book on Jewish life, was redacted, and that was in about 500 CE. Now, what does all of this mean for theories of law? What's important to understand is once the Talmud was redacted around 500 CE, Jewish law authorities at that point regarded themselves as unable to reinterpret the text of the written Torah. From then on, that was completely off limits. Once the year 500 came, the text of the written Torah could not be reinterpreted at any point in time from that point on. And so then what happened after that? Well, the rabbis, following that period of around 500 CE, were only able to develop Jewish law by extrapolating from the Talmud. Okay, the text of the written Torah was completely off limits. So what does this mean in terms of the boundaries of Jewish law? The boundaries of Jewish law, as this illustrates, are not provided by the text of the written Torah. Okay, when you look at the 5 books of Moses, when you open up the text, that's not what is providing the boundaries of Jewish law. Instead, the boundaries of Jewish law are being provided by the text of the Talmud, which was again redacted around 500 in the Common Era. So what does that mean exactly, that the boundaries of the Talmud were provided by that, and how does that impact lawmaking going forward? What ultimately it has to be understood about the Talmud is that there is gray in terms of what the Talmud has reached a consensus on in some areas. Okay? In other words, there's not a universal agreement, even within the classical tradition, as to what the Talmud conclusively decides. There's wiggle room, is what I'm trying to say. And then even when there is a consensus about a particular issue in the Talmud, it's not necessarily clear what that consensus is. So what I'm suggesting is that even in the classical Jewish tradition, even under an Orthodox approach to Jewish lawmaking, you have gray in the application of the law. So how does this resemble the theories of law, the absolutist theory of law? The Orthodox perspective on the development of Jewish law shares a very similar type of absolutist orientation in the same way that Jeff and David are talking about absolutism. The written Torah does not provide the basis for the absolutism, just like the text of the First Amendment does not provide the sole basis for the originalism that David spoke of. On the contrary, okay, in Jewish law, it is the text of the Talmud that serves the function of setting forth what the boundaries of the law are. Jewish law, nonetheless, manifests the same type of originalist-like structure by resorting to the text of the Talmud as setting up the boundaries. So according to the perspective of Jewish law, okay, the Torah, and here I'm defining that as both the written and the oral after the oral was redacted, does not evolve, and this is going to sound very familiar to what we said a few moments ago about David's view on absolutism. The Torah does not evolve to accommodate society, although it can forever be applied to new social realities. That language is virtually a mirror image recitation of the way that David and his co-author describe their position on absolutism. So the law doesn't change, but the law can be applied. All right. Now, again, that position in and of itself engenders an appreciation for the fact that the boundaries of the law are a little bit gray in certain instances, and the application of that, therefore, has to engender some grayness in the application. But the idea being is there's still a boundary. There's still a text, be it the text of the First Amendment or the text of the Talmud, that has to be reckoned with without resort to extraneous legal factors, without resort to sociology or economics or other non-legal principles. That is an absolutist view of the First Amendment / copyright law application, and that is the absolutist view that Jewish law maintains with respect to legal interpretation. All right, I want to be clear, that doesn't mean that there isn't fluidity among an Orthodox interpretation. There most certainly is, and I've had a lot of discussions with my co-director, Steve Resnikoff, whom I respect tremendously on this point. But the boundaries are less fluid. All right, now what about the Holmesian balancing position? Well, this was very interesting to me. All right, when I read the text of No Law and I saw the description of the Holmesian balancing, that was a very familiar discussion to me. And why is that? Because I was raised, born and brought as a conservative Jew, and I understand the lawmaking theory of the conservative movement, and it's exactly that kind of balancing process that was being discussed in the context of the First Amendment. Around the middle of the 19th century, just for some background, a European rabbi named Zacharias Frankel began to articulate what he called a historical approach to Judaism. Okay, well, what is that? It's very different from the approach that is today known as orthodoxy. Until this time, Jewish law was basically studied by the text. By that I mean the Talmud, the commentaries on the Talmud, of which there are many. But in this discussion of what Jewish law should look like, there was not introduced cross-cultural studies, linguistic comparisons, archaeology. None of that was within the purview of what Jewish law should look like. If you wanted to know what Jewish law had to say about a particular issue, you went to the Talmud, and then you went to all the commentaries following the Talmud. The historical approach opened up the universe of what kinds of factors should be considered in Jewish lawmaking. Now, it's also important to understand that the historical approach to Judaism differs from a theological standpoint as well. And although my focus today is not the theological difference, I need to just mention it because the theology drives the lawmaking, and it's important to understand that connection if you're talking about theories of law. So under a historical model of lawmaking in Jewish law, God did not necessarily dictate the text of the written Torah to Moses. Okay? Instead, the text of the written Torah was the product of human discourse over a period of centuries. It has a divine root because it's divinely inspired, but it wasn't necessarily under this position literally transmitted. And similarly, the oral law is not viewed as a series of commands that God gave to Moses, but instead the historical approach sees the oral law as a series of the embodiment of what the best judgment is of inspired humans addressing particular situations in their time. The consequence of the different theologies that I'm talking about should be clear, because it introduces the element of the possibility of a lot more fluidity into how legal decisions are going to be made. And that's exactly how lawmaking is done under the conservative movement. Zacharias Frankel is the ideological founder of the conservative movement of Judaism, which does adhere to the idea that the law is binding. But lawmaking under the conservative movement is different. Now, some of you, by the way, may be thinking, what about Reform Judaism? I am, or I know a lot of people that are Reform, and why isn't she talking about Reform Judaism? And there's a simple reason for that. I'm not talking about Reform Judaism because Reform Judaism doesn't believe the law to be binding. And so therefore, to have a discussion about how lawmaking takes place in the context of a movement that doesn't consider the law binding but just advisory isn't productive. Okay, you have to view the law as binding in order to be talking about the lawmaking process with any degree of seriousness. So that's why reform is not my focus in this particular project. All right, so the boundaries of the law in the conservative movement are much more fluid. And I want to just tell you a little bit about how lawmaking is done in the conservative movement so you can understand the link between the Holmesian type of balancing and what goes on here. In the conservative movement, there's a committee on Jewish law and standards. It's staffed by about 25 rabbis. They are responsible with coming up with the opinions that are essentially viewed as the opinions that ought to be followed in the North American community for conservative Jews. Israel actually has its own lawmaking body, and they sometimes have different views in terms of what the law should be. But nonetheless, Elliot Dorff, who is at this point the chair of the lawmaking committee in the conservative movement, would describe lawmaking in the following way, and think about how different this is from the absolutist perspective that I articulated before. Jewish law requires rabbis first to study legal precedents within historical contexts, and then to weigh them together with contemporary circumstances, economics, demographics, and a host of other Jewish forms of expression, stories, theology, history, morals, to make a considered, wise, and clearly Jewish judgment about what God wants of us now. I will also tell you that the early leaders of the conservative movement, the leaders in the 1920s and 30s, were very much interested or influenced by a very prominent Jewish jurist named Benjamin Cardozo, who called for a consideration of socioeconomic factors into the lawmaking process, not the Jewish lawmaking process, but the lawmaking process generally. So the boundaries in lawmaking, by virtue of the historical movement, are much, much more fluid. And that impacts, again, that comes from the theology, but it's executed in a much more liberal, influencing kind of way. And so I'm going to conclude my part of this, and then we can open this up for questions and comments, with drawing the connection between the Holmesian balancing and the historical approach. The operation of these two systems is very, very similar because, again, what you're doing is taking a look at the text and the tradition, but you're infusing that discussion with a consideration of socioeconomic factors and how the law should be shaped with respect to certain circumstances. And one more final comment that I would make in terms of shaping the law. It's true that the line between what the law is and how the law should be applied can be a fuzzy gray line. But one part distinction between the Orthodox perspective and the historical school of thought that I described is that under the historical school, even Torah law, by that I mean both written and oral, even Torah law can be changed or should be changed to accommodate new circumstances, not just applied differently, but should be changed at times. That perspective is not shared by the absolutist perspective. The absolutist perspective says Torah law does not change. It can be applied to new circumstances. Coming back now to David Lange's point about the absolutist theory of the First Amendment, the First Amendment under an absolutist theory does not get changed. Okay, it can be applied in new circumstances, but the law is the law, and it doesn't change. All right, so maybe we can now open up this discussion for questions, comments.